I would never be begging a nigga to be with me after he got a baby on the way. I would never be having matching t-shirts on with a nigga that got a baby on the way. I would never be trying to play family with a nigga that got a baby on the way. I would never want to be with a nigga that burnt me while I was pregnant. I would never want to be a bitch like that. I would never be telling random people that my baby daddy burnt me. I would never tell nobody no shit like that. I would never tell random people that my baby daddy cheated on me our whole relationship, my whole pregnancy, that he cheated on me. I would never, you could never get me to tell no shit like that to no random people that I don't fucking know. I would never want to have a job to where I'm wiping old people's ass and giving old people showers and feeding them and shit. I would never want to have a job like that. I would never want to have a job that my car was in the shop for 2 years. I couldn't get it out. I would never want to have a job like that. I'm wiping ass and I ain't got no car still. I would never want no job like that. I would never want to be with a nigga that done got so many bitches pregnant during the time that I've known him. I would never want to be with a nigga like that. I would never want to be with a nigga that done play in my face for damn near 10 years. I would never want to be with a nigga like that. I'm getting me a new nigga ASAP. I would never have a big ass birthday party and have to catch a ride to my birthday party because I don't have a car. I would never.
The courtroom was quiet long before the judge entered. Not silent in the way of emptiness, but tense in the way of anticipation. Reporters adjusted their cameras. Legal pads were flipped open. Family members sat stiffly, hands folded, eyes fixed forward. Yesterday's pretrial hearing in the Romeca Meeks case was not expected to deliver a verdict. It was not a trial day. But what unfolded inside that courtroom has shifted the tone of this case in ways few anticipated. Before we break down what happened, I want to welcome you to the channel. We look for the truth in the shadows of cold cases and closed files. If you value this kind of deep dive investigation, please consider subscribing. And as we begin this journey together, I'd love to know where you're watching from today. Whether you're joining us from the United States, Canada, Australia, or anywhere else in the world, leave a comment below. It helps us remember that these stories, though local, touch hearts across the globe. What happened in court yesterday was procedural on paper, a pretrial hearing, motions, arguments, clarifications. But anyone who has followed this case understands that pretrial hearings are where the battlefield is quietly prepared. This is where legal strategies are sharpened. This is where evidence is challenged. This is where narratives are shaped before a jury ever hears a word. Romeca Meeks' death shook her community. The shooting, the circumstances surrounding it, the presence of a child, the conflicting accounts, all of it created layers of tension that have not subsided. For months, both prosecution and defense have been maneuvering strategically, filing motions, challenging evidence, and positioning themselves for what will eventually become a full courtroom reckoning. Yesterday, something changed. The prosecution entered the hearing with renewed intensity. Their posture was deliberate, and they referenced newly analyzed forensic details and supplemental evidence reviews that had been completed in recent weeks. While the full contents of those analyses are not yet public, the tone signaled confidence. Legal observers noted the phrasing carefully. Words like expanded scope, additional corroboration, and contextual reconstruction were used repeatedly. In legal language, that often suggests that investigators have re-examined timelines, physical evidence, and digital footprints. The defense, in turn, doubled down on their core argument, self-defense. Their claim remains that the defendant believed there was an imminent threat. That belief, they argue, shaped every decision made in those critical seconds. But the prosecution's emphasis yesterday appeared focused on challenging not just actions, but perception. They raised questions about distance, about angle, about timing, about whether the level of force used was proportional to the alleged threat. And these are not minor distinctions. In cases involving self-defense claims, the question is rarely only whether force was used. It is whether the force was reasonable under the circumstances. The judge listened without visible reaction. That neutrality is standard, but it did not diminish the weight in the room. At one point, prosecutors referenced surveillance analysis enhancements. The phrase alone caused murmurs among attendees. Surveillance footage has always been a critical element in this case, but enhancements imply new clarity, new frames, possibly slowed sequences or sharpened imagery. The defense immediately objected to characterization, arguing that enhanced footage can alter perception if not carefully contextualized. This exchange marked the most intense moment of the hearing. It was not loud, it was controlled. But beneath the professional tone was unmistakable friction. On another development emerged regarding witness testimony, the prosecution indicated they intend to call an additional behavioral expert. That detail is significant. Behavioral experts are often used to interpret reaction patterns, body positioning, and situational awareness. If introduced, such testimony could attempt to reconstruct not just what happened physically, but how the individuals involved may have been processing the situation psychologically. And the defense responded by stating they would challenge the admissibility of any speculative behavioral conclusions. Again, this is strategic. Each side is fighting to define what the jury will be allowed to hear and how that information will be framed. Pretrial hearings often revolve around admissibility. What evidence comes in? What stays out? What is redacted? What is contextualized? Yesterday's hearing revealed that both sides are preparing for a deeply technical trial, and not one driven solely by emotion, but by precision. Then came what many are calling the bombshell. Prosecutors reference phone data timeline analysis that may narrow the window of events more tightly than previously understood. While specifics were not disclosed in open court, the suggestion was clear. Digital timestamps may contradict earlier assumptions about sequence. Sequence matters. In any self-defense case, the order of actions can determine interpretation. Either will shape the jury's lens. The defense will shape the jury's lens. The defense appeared measured but firm. They requested full disclosure of underlying data sets and indicated they will conduct independent digital forensic review. This suggests that the coming weeks will involve technical back and forth between experts. Another notable moment came when the judge addressed bond status. The court reaffirmed the existing detention ruling, no modification, no adjustment. The reasoning cited community safety considerations and flight risk analysis previously established. That decision maintains pressure on the defense. Detention status often influences negotiation posture, though no plea discussions were referenced publicly. Family members of Romeca Meeks were present. They did not speak. They did not need to. Their presence alone carried weight. So grief in a courtroom does not shout. It sits quietly and watches. As the hearing concluded, the next pretrial date was set. Additional motions are expected. The trial timeline remains on track, though legal observers caution that complex evidentiary disputes can cause delays. What does all of this mean? It means the case is tightening. It means both sides are refining strategy. It means digital evidence may play a larger role than previously anticipated. It means behavioral interpretation could become a central battleground. It means this trial will likely hinge not only on what happened, but on how those moments are reconstructed frame by frame. And reconstruction is powerful, because once a narrative solidifies in jurors' minds, it is difficult to undo. The prosecution is signaling that their narrative is strengthening. The defense is signaling readiness to dismantle it piece by piece. That tension is where truth will be tested. Yesterday was not a verdict, but it was momentum. Momentum in legal cases is subtle. It shifts quietly. It emerges in phrasing, in confidence, in body language, in what is emphasized and what is not. Those who have followed this case from the beginning understand that each development adds dimension. Each motion filed reveals what each side fears most. Each objection signals strategic vulnerability. And yesterday, both sides revealed just enough to show that the upcoming trial will not be simple. It will be layered, technical, psychological, emotional, and intensely scrutinized. The community continues to watch, and so do we. As the courtroom emptied, the conversations did not. They simply shifted locations. Hallways became quiet strategy rooms. Outside steps turned into impromptu analysis forums for reporters and legal observers. What happened inside that room may have lasted less than an hour, but its implications extend far beyond a single hearing. To understand why yesterday's pretrial moment is being described as a turning point, we need to revisit the foundation of this case and the layers that have built up over time. The death of Romeca Meeks was not just another headline. It was an event that unfolded in daylight, in proximity to routine life, in the presence of a child. That context alone shaped public perception from the beginning. When tragedy intersects with ordinary moments, the shock multiplies. It disrupts assumptions about safety, about predictability, about control. Early reports framed the event through fragmented accounts. Witness recollections varied in emphasis. Some described confrontation, others described confusion. Law enforcement statements were cautious. The defendant's claim of self-defense immediately established the central axis of the legal battle. Self-defense cases often pivot on split-second judgments. The law allows for protection when imminent threat exists, but that allowance is bounded by reasonableness. The reasonableness standard is where juries wrestle. It asks them to imagine themselves in that moment while also applying objective evaluation. That tension between subjective fear and objective assessment is what will define this trial. Yesterday's hearing suggested that prosecutors believe they can narrow that tension by focusing on timing, digital evidence, and enhanced footage. They appear prepared to argue that the perception of threat may not align with reconstructed reality. Reconstruction is not speculation. It is compilation. It involves mapping seconds to movement, aligning timestamps with trajectories, comparing audio to physical positioning. When prosecutors reference timeline compression, legal analysts immediately recognize the implication. A compressed timeline can eliminate ambiguity. If events occurred faster than previously assumed, it could alter whether there was opportunity to disengage. If events occurred slower, it could raise questions about escalation. The defense, for its part, remains anchored in the emotional dimension of the moment. Their arguments suggest that fear does not unfold with perfect clarity. It unfolds with adrenaline, with instinct, with protective reflex. They are likely to frame the incident not as a sequence of calculated decisions, but as a reaction within perceived danger. That framing will resonate with some jurors. It always does. The question will be whether evidence supports that perception. One of the most quietly powerful developments yesterday was the mention of additional witness clarification. While no new eyewitness was formally introduced in open court, prosecutors alluded to refined statements obtained after further interviews. That detail suggests that investigators have revisited earlier testimony, perhaps reconciling inconsistencies or clarifying vantage points. Witness evolution is common in complex cases. Memory stabilizes or shifts after repeated recall. Defense attorneys often scrutinize those shifts carefully, highlighting any discrepancy as instability. Expect that to become a focal point moving forward. Another subtle but meaningful element was the prosecution's tone when discussing physical distance. Distance in self-defense cases is critical. It determines immediacy. It informs threat level. If digital mapping or surveillance analysis indicates greater separation than initially reported, that could undercut imminence. If it confirms close proximity, it may reinforce the defense's narrative. The ambiguity surrounding that detail is likely intentional at this stage. Neither side reveals full strategy in pretrial hearings. They signal just enough to test reaction and preserve leverage. Community reaction has been divided from the outset. Yesterday did not resolve that divide. It sharpened it. Observers noted that when prosecutors mentioned enhanced footage, members of the gallery leaned forward almost in unison. Visual evidence carries persuasive power beyond verbal description. Even the suggestion that clarity has improved can influence public expectation. If that footage becomes central at trial, it will likely be dissected frame by frame. Jurors may watch it repeatedly. Experts may pause, rewind, annotate. In that repetition, interpretations will solidify. The defense's challenge to enhancement methodology signals anticipation of that impact. They may argue that lighting adjustments or zoom features create artificial emphasis. The courts often allow enhancement if original footage remains accessible for comparison. The debate will revolve around fairness and representation. Another dimension emerging from yesterday's hearing is psychological framing. Behavioral experts, if admitted, could testify about reaction patterns under stress. They might analyze body orientation, hand movement, head positioning. The prosecution could use such testimony to argue that movements were inconsistent with imminent threat. Yes, the defense could counter with their own expert, emphasizing fight-or-flight response. When juries hear dueling experts, the battle often shifts from facts to credibility. Which expert appears more grounded? Which explanation aligns with common sense? These are intangible but decisive factors. The judge's reaffirmation of detention status maintains structural gravity around the case. Pretrial detention often shapes public perception subtly. It suggests seriousness. It reinforces the weight of charges. Though legally neutral regarding guilt, its psychological effect is undeniable. As legal teams exited the building, neither offered extensive comment. That restraint is strategic. Public statements at this stage risk influencing jury pools and complicating proceedings. Silence in high-profile cases is often deliberate. What remains clear is that yesterday's pretrial was not routine in impact. It marked the transition from narrative establishment to technical contest. Early in a case, storytelling dominates. By mid-phase, mechanics take over. We are now firmly in the mechanical phase. Timelines, angles, audio clarity, metadata, behavioral modeling. All of these elements are converging toward a singular objective: to shape how 12 jurors will interpret one irreversible moment. And in that convergence, the smallest detail can carry extraordinary weight. The coming weeks will likely bring additional motions. There may be disputes over admissibility of phone extraction data. There may be arguments over whether certain witness statements constitute hearsay or fall under exception. There may be efforts to suppress portions of footage. Each motion will function as both shield and sword. Observers often underestimate pretrial hearings because they lack dramatic testimony. But seasoned legal analysts know that trials are often decided before opening statements. They are decided in what evidence survives pretrial challenge. Yesterday, prosecutors signaled confidence in their evidentiary foundation. Defense signaled vigilance in dismantling it. That equilibrium sets the stage for a trial that will demand attention. For the family of Romeca Meeks, the process continues to unfold slowly. Court dates mark time in months rather than moments. Each appearance reopens grief. Each argument revisits loss. The legal system moves deliberately by design, but for families, deliberation can feel like delay. As we continue following this case, our role remains observation grounded in respect. We do not speculate beyond evidence. We do not dramatize beyond reality. We examine developments carefully, contextualizing them within legal structure. Yesterday's hearing provided clarity on one point above all others. This case will hinge on interpretation of seconds. Seconds of movement, seconds of perception, seconds of decision. Those seconds are now being reconstructed with increasing precision. Whether that precision supports prosecution or defense remains to be seen. But the tightening of narrative suggests that when trial begins, it will not be vague. It will be exacting. When exacting trials often produce outcomes that reverberate beyond a single courtroom. We will continue monitoring filings, motions, and emerging disclosures. Each development will add dimension. Each court appearance will refine strategy. And as the legal path narrows toward trial, the questions raised yesterday will grow sharper. In the days ahead, legal filings will continue to accumulate quietly in digital dockets, and the language inside them will matter more than any headline. Emotions will be drafted with precision, citations layered carefully, arguments constructed not for public consumption, but for judicial scrutiny. Yet even as paperwork multiplies, the human core of this case remains unchanged. A life was lost. A child witnessed the aftermath of irreversible action. A defendant maintains that fear dictated response. A prosecution maintains that evidence will show something different. Yesterday's pretrial hearing did not deliver resolution, but it clarified direction. The direction now points toward a trial defined not by rumor or assumption, but by measured reconstruction. It points toward experts explaining seconds in microscopic detail. It points toward jurors watching enhanced footage in silence, absorbing angles and movement. It points toward competing interpretations of the same moment, each presented with conviction. When prosecutors referenced refined digital timelines, they were not simply introducing data, they were signaling confidence in sequence. Sequence is structure, Structure is narrative stability. If they can anchor every action to an unbroken chain of timestamps, their argument becomes less about emotion and more about inevitability. The defense, aware of that risk, will likely work to introduce elasticity into that chain. They may question device accuracy. They may highlight potential lag in recording systems. They may argue that human perception does not align perfectly with technological capture. This clash between technological precision and human instinct will sit at the heart of the trial. The mention of behavioral expertise further complicates the picture. Behavior under stress does not always mirror logic under calm. The prosecution may argue that body orientation and spatial dynamics contradict imminent danger. The defense may counter that instinct overrides orientation in moments of perceived threat. Jurors will be asked to imagine fear while analyzing footage with clinical detachment. That dual demand is heavy. It asks for empathy and objectivity simultaneously. The reaffirmation of detention status underscored the seriousness with which the court views the charges. It also maintained a steady procedural rhythm. No surprises in bond. No deviation from prior rulings. Stability in pretrial structure often signals judicial confidence in process, and process is moving steadily toward confrontation of facts before a jury. Community reaction remains layered. Some interpret the prosecution's references to new analysis as strengthening accountability. Others interpret the defense's steadfast tone as evidence of confidence in self-defense claims. Public opinion, however, will ultimately yield to jury determination. The courtroom is the only arena that will matter when opening statements begin. For the family of Romeca Meeks, each court date carries weight beyond legal terminology. It carries memory. It carries absence. It carries the quiet endurance required to sit through procedural debate while living with permanent consequence. That reality does not shift with motions or enhancements. It remains constant. As we reflect on yesterday's pretrial, the phrase bombshell must be understood in context. There was no dramatic confession, no sudden dismissal, no surprise witness revelation in open session. The bombshell was structural. It was the indication that evidence refinement is ongoing and potentially narrowing interpretation. It was the realization that this case is entering its most technical phase, and technical phases often decide outcomes long before jurors retire to deliberate. When trial begins, the groundwork laid in hearings like yesterday's will determine what the jury sees, hears, and weighs. Each objection argued now will shape the boundaries of testimony later. Each motion filed now will influence narrative clarity at trial. The coming weeks may bring additional evidentiary disputes. There may be arguments over metadata admissibility. There may be challenges to expert qualifications. There may be renewed debate over what constitutes reasonable fear. These disputes are not distractions. They are architecture. They build the framework within which truth will be examined. As observers committed to careful analysis, we recognize that justice unfolds methodically. It does not rush to satisfy curiosity. It advances step by deliberate step, guided by standards that prioritize fairness over speed. Yesterday was one of those steps, a step that signaled readiness, a step that revealed tightening strategy, a step that moved this case closer to a defining moment. When the trial begins, attention will intensify. Cameras will return, analysts will dissect testimony, headlines will sharpen, but beneath all of that, the central questions will remain steady. What happened in those seconds? Was the threat imminent? Was the response reasonable? Did perception align with reality? Those questions are now moving toward structured examination. And when that examination concludes, a verdict will not simply close a file. It will define how those seconds are remembered legally and historically. Until then, we continue to watch. We continue to analyze developments as they emerge. We continue to approach this case with respect for its human impact and awareness of its legal complexity. The shadows surrounding cold cases and active trials alike require patience to navigate. Truth does not always arrive dramatically. Sometimes it emerges quietly through data, through testimony, through procedural persistence. Yesterday's pretrial hearing reminded us of that. It reminded us that even in rooms where little appears to happen, momentum can shift. And in this case, momentum is unmistakably building. Thank you for following this update with us. Stay attentive, stay thoughtful, And as always, we will be here, examining each development carefully as the path toward trial continues to unfold.